So today we are going to discuss the top 10 ways to avoid a grievance complaint. It'll go about an hour. We'll probably save about 10 minutes before the hour is over to allow for any questions that you may have. And there's a way to submit that. And when we get towards that end of the materials, or actually during the course of the materials, I am going to give you a passcode. And if I forget to do that, then Diana will remind me to do that. And that you will need that code to enter in order to get your CLE credit today. Before we jump into the top 10 ways to avoid a grievance complaint, and I kind of created this PowerPoint from just my experience being an attorney and also my time when I was on the grievance committee for the Westchester County Bar. These were essentially common issues that I saw were reoccurring or questions that colleagues regularly asked me about. So I kind of wanted to compile those types of questions and address those types of issues in this PowerPoint. So we will address those issues, those 10, I call them most common or most important. They're all important issues, but I kind of concentrated on these top 10 issues. By no means is this list an exhaustive list. There are many other issues, many other ethical pitfalls that we need to be aware of, but these are what I think are the top 10 most important ones. But before we actually get into those top 10 issues, we should probably explain or have you become more familiar with a grievance complaint. Hopefully, none of you have ever seen a grievance complaint, but I just wanted to kind of stress that this grievance complaint is taken very serious. And these complaints are encouraged by the grievance committee as a way of policing the conduct of attorneys, because there is no ethics sheriff that will, knock on your door or anything like that. The only way a grievance committee becomes aware of potential issues is from the public, the filing of grievance complaints. The grievance committee can also sua sponte file a complaint, but those are usually if they become aware of a crime that was committed, or there may be some issues with some type of advertising that an attorney has put out there. But other than that, particularly important thing to stress is that the complaint is not a phone call. A complaint must be in writing, and it must be signed by the complainant. It's not anonymous, and it has to set forth the act of professional misconduct on the part of that attorney. What is professional misconduct? It's a violation of any of the rules of professional conduct and or a violation of any rule or announced standard by the appellate division governing the personal or professional conduct of attorneys. If it does not state an act of professional misconduct, through a screening process that the grievance committee employs, it will be dismissed. We do have a complaint form. That's your exhibit number 1. I just wanted to include that in your materials so you can see the format of that complaint form. If you wanted to turn to that exhibit, it's a grievance committee complaint form. This one is for the second judicial department. And as you can see on the first page, it's relatively a simple form. It's just complainant information, the attorney that's complained of, have you had contact with other agencies, any court action taken by you against the attorney, and then a second page is your allegations. The complainant's allegations against the attorney. What do you believe the attorney did that was improper? That's where the act of professional misconduct has to be reflected. And on the bottom it says, please sign here. There's no fee for filing a complaint. It doesn't have to be notarized, but it does have to be writing and have to be in writing and signed by the complainant. Who can file a complaint? Anybody. It does not have to be the client. As I said earlier, even the grievance committee can file a complaint. So essentially, there's a reason that this complaint form is not burdensome to the complainant. As I mentioned before, the legal profession is self-governed. So they want to see these complaints. They could always screen out ones that don't have merit, but at least they're able to take a look at these complaints and address them and go through the screening process. Okay, so let's dive into the top 10 ways to avoid a grievance complaint. The number one issue, and well, I call all of these issues, I title them things that can keep you up at night. The number one is to know your client. I can't stress how important that is. You need to know if you're representing an individual, for example, how sophisticated are they? Are they a sophisticated developer, or is this their first purchase of a house? What is their level of understanding this real estate transaction? The good, bad, or ugly, you need to know about your client. Do they have an online presence? Are you dealing with somebody who will be available for the closing? If not, will you need a power of attorney for the closing? As you all know, there's a form that came out last year, a new power of attorney form. So as a reminder, you will need to use that form unless you had prior forms that were executed prior to the change last year. And it's always important to know that you're going to need a power of attorney because you're going to need that to record at closing, most likely if it's being used to execute any of the recordable documents. If your client is an entity, you want to know where it was formed and when it was formed, who formed it, what's its purpose. Very important. Does it have all of its formation documents? And when I say formation documents, you're talking about for corporation, certificate of incorporation, bylaws. You want to take a look at minutes if those are available. Limited liability companies, you're talking about the filing receipt, your articles, your operating agreement, especially your operating agreement, because that's going to identify all of the members and authorized parties for that entity. Rule 1.13 of the New York Rules of Professional Conduct stresses the importance of explaining to your client or having them understand who you're representing for a specific transaction. If you're representing an entity, you're representing that company. You're representing that corporation or limited liability company. You're not representing the employees, the officers, the directors. You are the attorney for that entity itself. As I mentioned before, continuing on with limited liability companies, a very important document critical to a real estate transaction, which is unfortunately overlooked in the formation process, is the operating agreement. New York Limited Liability Company Law, Section 417, states that operating agreement must be created within 90 days of filing the articles of organization, and that operating agreement is going to reflect the company's purpose. It's going to, as I mentioned before, mention who the members of the limited liability company are, as well as their powers to act. And particularly for a real estate transaction, title companies want to see that, as well as banks and bank attorneys. They want to know who is authorized to bind the company. So that is very, very important. What happens if you don't have an operating agreement? Sometimes I've been seeing operating agreements brought to the closing to be signed. That's not a good idea. You, as an attorney, you want to make sure that you've done your due diligence to make sure that you're able to identify who the members are of that limited liability company is. So that means doing a little investigation, not only at intake with your client, but possibly external sources, meaning you may reach out to their accountant, you may review their tax returns, K-1 schedule, which reflects a member's interest in companies like limited liability companies. This is information that you're going to want to take a look at to make sure that the person signing on behalf of the LLC is authorized to sign a deed or sign the mortgage or any other critical document to a closing. You are, for a corporation, New York Business Corporation Law, Section 601, corporation must adopt bylaws at organizational meeting. Again, you need to confirm the power and authority. That you would need to review the books, take a look at who the shareholders are, and who can be an authorized person to bind the company and sign transactional documents on behalf of that entity. You may recall that there were amendments to the tax law, Section 1409, New York City Administrative Code, Section 11-2105. Judicial sent out some judicial notices on that. It creates a recording requirement for deeds conveying title to residential real property containing 1 to 4 family units where the grantor or grantee is an LLC. So essentially, there's an addendum that's required to those transfer tax forms, which requires you to kind of peel the layers up for limited liability companies, peel away the layers until you actually come to a natural person. That information needs to be reflected on an addendum and submitted with those documents. Unfortunately, LLCs and corporations, their shareholders and members are not public record with the New York Department of State. It would be great if they had some type of system to reflect that. It would make, I know, our job as attorneys a lot easier because we can kind of defer the Department of State as to who has authority, who controls this entity. Unfortunately, there's no such thing. There is a recent bill that was introduced, which is essentially asking or requiring for limited liability companies to disclose the names and addresses of the beneficial owners of that entity. We'll see where that goes. Personally, I would like it to go even further to see possibly somebody being designated as an authorized person who can bind the company that third parties can rely on. But maybe they'll develop into that. We'll see. But for the time being, we can only, as attorneys, rely on our due diligence and investigating these entities and coming up with as much information as we can in order to make sure that this authorized person is actually authorized to bind the company and execute transactional documents. Okay, second issue, piece of advice, always put it in writing. Rule 1.5b of the rules says that a lawyer shall communicate to a client the scope of the representation and the basis or rate of the fee and expenses for which the client will be responsible. That's in every situation. Now, they're not essentially talking specifically about a retainer or letter of engagement in that situation. Communication that way could be just by an email or verbal communication. However, if the legal fee to be charged is expected to be $3,000 or greater, a written letter of engagement or retainer agreement is required. And that letter must detail the scope of the legal services in which you're going to reflect what this matter is, or real estate transaction, whatever it is. You recite the specific address of that property, the particular legal services that you're going to provide, and more importantly, what you're not going to provide. If you're just representing them in the course of the transaction, limited to that. If there's any litigation, you don't want to handle that, reflect that this does not entail any litigation or appeals or anything of that nature. You want to make sure that that is very limited and clear in writing. Also, you have to explain your fees. If it is a flat fee or some other type of fee that you're going to be charging the client, that needs to be explained. Is it paid up front or is it paid at closing? Is it when is it paid? How is it paid? And lastly, the notice of right to arbitrate under New York law or New York Code rules and regulations. There's a mandatory fee dispute resolution program for fee disputes for sums of $1,000 to $50,000. They have to be resolved through the mandatory fee arbitration process. So that has to be in there as well, so the client is aware of that. So what's so important about this, and I say I'm looking at the $3,000 requirement. My recommendation is I always have a retainer agreement drafted up, because I don't want there to be any question as to what services that I'm going to be providing and what I'm not. I also use retainer agreements as a way of putting the client on notice of certain things, the importance of various inspections, building inspections, mold, radon, anything of that nature, important deadlines, providing what are the client's obligations under this agreement, to notify the attorney of any deadlines, whether they be rate lock or a mortgage contingency. All of that needs to be reflected or should be reflected in your letter. And a very important caution, and we're going to get into this subject a little bit later on, are wire fraud cautions. And I have actually a few wire fraud caution notices in your materials that I would suggest putting in there. You can use any one of those or a combination of them, or kind of make your own out of that language. But I do recommend putting notices in, making your client aware of wire fraud. It's very prevalent, especially with real estate transactions. You want to make sure that your client is not going to quickly wire something. That you want to make sure you're in control of that wire instructions are being verified and they're not being sent to somewhere they shouldn't be sent. There's a case also in your materials, the Itala v. Milbank case. That's a case which really stresses the importance of a written retainer agreement. And essentially what the court was saying there was an attorney is not liable for failing to act outside the scope of a written retainer agreement. They fortunately had limited their services to just investigating and considering a possible litigation matter. And they went so far to say, we are not going to commence any type of action. We are just exploring or investigating your options. And this malpractice case that was brought by the complainant, the court essentially said that that letter was crucial, and by reason of that letter, there was no malpractice because they weren't acting within what the duties specified in that specific agreement. Oh, one other thing in terms of retainer agreements I wanted to stress was when you're representing a purchaser, I also add in my agreements, I stress the importance of a survey. Of course, it's up to your client whether they're going to get a survey, but if there is no survey at a closing, you're closing on the survey, there's some issues, very crucial issues that could come up out of possession issues that you are not aware of. So in my letters, I also make sure that I stress the importance of the need for surveys. Number 3, just say no. If a prospective client or transaction doesn't seem right for you, decline the representation in a clear and decisive manner in writing. You always want to put it in writing, just to stress the finality of it. Withdraw from representation if permissible. Of course, you don't want to withdraw from something if it's going to material or substantially harm the client. But if permissible, I would say withdraw from that representation. And I think one red flag when you have a client intake or you are speaking to your client for the first time is, if they're hesitant on giving you a lot of information as a red flag. Also be wary of those clients that from get-go try and negotiate your fee. It's 9 times out of 10, it's a red flag, and usually there's going to be an issue, or it's going to be or you could foresee it's going to be a very, very difficult representation if you're starting with that. To me, I think it's, you're setting your fees because you've been in the field for so long. You know what you're worth and what your services are worth. And if from the get-go, your client's already saying, no, I want to pay you less. That shows you, how the client perceives your worth and how, your mindset's going to be going into this is I'm being paid less than what I really should be. That's not a good mindset to be going through with a representation. So to the extent that you can, I would say stay firm with your fee. You deserve it. And be careful of those clients that come in trying to lower that. Particular rules that are applicable are Rule 1.2. A lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is illegal or fraudulent. Rule 4.1. In the course of representing a client, A lawyer shall not knowingly make a false statement of fact or law to a third person. And Rule 8.4, a lawyer shall not engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. You want to make sure that the representations that you're providing to your client are correct. If you're investigating a property, which you know is not suitable for the uses that your client is intending it to be used for, you want to make sure that that information is clearly disclosed and discussed with your client. So for instance, if you're looking at a location where somebody wants to start a business and in that zoning district that isn't permitted and you're aware of that, you need to make sure that you are informing your client of that. Also be wary of attorney opinion letters that you're providing to the bank or any other party. You're representing that client and you're stating in that letter, along with many other things, that an entity has been duly formed and that the person signing the documents is the one authorized on behalf of the entity to do so. If you become aware along the way that there's other members, that this person is not authorized, or you need approval of other members or parties in that entity, then you need to make sure that that is addressed. 4, always be learning. Rule 1.1 states a lawyer should provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for the representation, and a lawyer shall not intentionally fail to seek the objectives of the client through reasonably available means. And there's a comment to that rule which says that attorneys must keep abreast of the benefits and risks associated with technology the lawyer uses to provide services to clients or to store or transmit confidential information, which essentially they're saying you as an attorney, you need to make sure that you have enough knowledge in the technical field and the technology field to protect your client's confidential information. You want to make sure that your servers are protected, the programs you use are protected, your systems are protected, emails, the documents that you prepare are protected. There's, when you work in a Word document, there is what they call metadata, which is information that is automatically stored to specific documents. So if you're using a particular Word document and you're reusing it as your clients, as you have different clients, the information that you had used for prior clients is embedded in that document. So you want to make sure that you are addressing that. There's certain programs that you could use to wipe that metadata. The best way, I think, is to just send PDFs of documents to address that particular information. Essentially, you need to safeguard your client's information and keep abreast of the information, the technology at your office, and make sure that the associates in your office are familiar with that as well. Number 5, watch your wires. I think if I should have made this even more bold in my PowerPoint. Watch your wires. So important today. I cannot stress it more than I'm doing now. You have to make sure that the wire that you're sending or that someone else is sending is going to hit the intended account. because essentially the banks, the Fed, they're not responsible. The person responsible for issues with wires is the attorney, the person who's sending those wires. And if you take a look at your materials, this is 5 in your materials, Exhibit 5. This is, I put a copy of Regulation J because it's just so important to take a look at and read. Essentially, it says, the Fed may rely on the number in a payment order that identifies the intermediary bank or beneficiary's bank, even if identifies a bank different from the bank identified by the name in the payment order. The Federal Reserve Bank has no duty to detect any such inconsistency in identification. And then it goes on to essentially mirror and say that the Federal Reserve Bank, acting as a beneficiary's bank, may rely on the number in a payment order that identifies the beneficiary, even if identifies a person different from the person identified by the name of the payment order. So essentially, when you're putting in an account or the account information is put in, and you're saying the beneficiary is John Doe, and instead Peter Wilson comes up, the Fed is not responsible for holding that wire or preventing that wire from going through. If there's any inconsistencies, whether it's with the account holder or the beneficiary bank, meaning if that wire is supposed to go to Wells and the ABA number instead is for Citibank, again, the Fed is not responsible. So going on, you may think, oh, well, maybe, so then the bank should be responsible. No, not the bank is not responsible, because if you take a look at your wire transfer agreements, and I put in a couple here. There's one from Wells and I have one from Citibank. And essentially, if you take a look at the second page, all the important information is in small print on the second page. Unfortunately, as attorneys, we all have to sort that out. It's almost like they're trying to hide this stuff. But there's limitation of liability in the Wells transfer agreement, which you're signing to send out that wire. The bank will not be liable for any loss or damage due to the failure or error of, and then it goes on, the method of transmission selected by the bank. And then it says further, in no event will the bank be liable for damages arising directly or indirectly if the order is executed by the bank in good faith. Bank may rely solely on the account number of the person, beneficiary, who's to receive the wire transfer rather than the beneficiary's name. And it provided by you on the identification number of any other financial institution through which the funds are to be transferred, rather than the name of the financial institution. So essentially, these notices are almost mirroring what the Fed under Regulation J is saying, that they have no responsibility. All the responsibility and obligation is on the attorney that's sending the wire. Okay, so in furtherance of that, again, I stress, verify your wire instructions before sending out the wires. Double check them, triple check them, make sure they're accurate, and make sure that where you're getting the wire instructions from is a way that is protected or verified, whether it was sent to you, by overnight mail, you could trust directly from another attorney, or whether you get them by email, you need to verify verbally with the number that you trust. And your clients should also be advised of this. If you take a look at the Duran complaint, they ended up settling that case, but in that case, this was a complaint against Attorney Duran for malpractice, whereby the Millards were purchasing a cooperative apartment in Manhattan, and for the purchase price was about $20 million for a co-op in Manhattan. And they were required to send a payment of 10% deposit, about $2 million, to the seller's attorney. Well, in this situation, Attorney Duran's email was hacked, and it was monitored by the cyber criminal to know just the right time to strike. Now, these cyber criminals are very savvy. This is their job. So they are going to take a look at your emails. And when it comes to a point where you're needing to wire something, they are going to send their email. Unfortunately, in this situation, they hacked directly into Attorney Duran's account. She purportedly, the cyber criminal acting through the email, representing themselves to be the Attorney Duran, sent an email to the clients to wire that $2 million to these wiring instructions. Now, and that's exactly what happened. And there was a day that went by. The next morning, that cyber criminal sent an email to the Attorney Duran saying, "Oh, we received the wire, thank you." But that email didn't, there were some misspellings in the email that came over, some variations. At that point in time, cyber criminals are just trying to buy for time so that they can get rid of those wire funds, those illegally obtained funds, as soon as possible, and various other accounts. So you have all of these layers that happen here that, could have been prevented. Number one, by verifying wires before they go out, by taking proper protocols to make sure that your email won't be hacked, or identifying if it has been. Check your sent emails to see if anything's been sent. Monitor that. Have a written retainer letter with your client. As I indicated before, I always put my retainer letters, there's that wire notice, and it says in bold, do not send any wires without verifying with me directly. And then I verified the wiring instructions. Do not, make sure that is in there. Unfortunately, here there was no notices to the client. So, these are people that are, probably not as sophisticated. They're not developers. They're making a purchase. They're not familiar with these types of issues that we are now familiar with. So you want to make sure that you're able to make sure your client is aware of this and that you have the proper protections to make sure it doesn't happen. Let me stop briefly because I know I have to provide you with the code, the passcode for our course today. Our presentation is client. The code again is client, CLIENT, client. So again, the passcode is client. Phishing. You might have heard the word phishing when it comes to cyber attacks. They involving fraudulent communications appearing to come from a legitimate source. So you may get these emails important, do not click on these emails. They're becoming very good at this. A lot of these look legitimate, but they're not. And once you click on one of these things, you enter your login and password. These cyber criminals have all the information they need. Here's another one that was sent, an example from Rackspace. More importantly, you missed a scheduled Zoom conference meeting and they want you to click on something. Do not do that. You want to make sure that you verify, make a phone call, ask what this is about before clicking on that. You want to make sure you're protecting yourself from any potential issues, malware, anything that is going to affect your system. Most reports of fraud in real estate in 2021 involved email account compromise. The FBI reported over $2.3 billion in losses last year due to email account compromise. As I indicated, there was an example of that Duran complaint. That was an example of email account compromise. They access your email account, assume the identity of the attorney, or they could be a broker or a party to the transaction, and send fraudulent wire instructions to that person's account. And those wire instructions would be directly to the cyber criminal's account instead of to the other attorney's account or to a lender's account. Use safe email practices. Always use a secured Wi-Fi connection. Use strong passwords for your email. Monitor your email accounts. As I said, review your sent file to make sure that no one is sending any emails fraudulently from your account. Update your operating systems and antivirus programs. Verify sender's email address and call to confirm that email is genuine. That's important. And again, add a wire fraud notice to your emails. 6, communication is key. The most common grievance complaint involves attorneys' failure to communicate with their clients. So you want to make sure that you're keeping your client informed every step of the way. Whether it's a document that you're preparing or a conversation that you've had in negotiating with the other party, you have obligations under the rules to keep your client informed as that transaction progresses. A lawyer shall explain the matter to the extent reasonably necessary to permit the client to make informed decisions regarding the representation. So in order for them to make an informed decision, you need to make sure that you become informed with that particular transaction, come up with what alternatives, what courses of action you can take, and then present that to your client so they can make an informed decision. Make sure you respond to your client's calls or emails or other correspondence from fellow attorneys. Rule 1.4 is the applicable rule there. Make sure that you be careful with the reply all email. That could get you into danger unless you know every person that's copied on that email. You don't want to respond to someone that you don't know. I've seen some emails that attorneys have sent where they're copying their client. I'm not big on that. I would rather send them the entire chain after I've talked to the other attorney. And I usually kind of drop the client off of the email if I get somebody that's copied there. I just, I don't want to make representations or make it more difficult to the attorney on the other side. or unless of course it's something where you're in negotiation for something and you need their input. That's different. If both sides agree, both parties agree, that's different. But I just wouldn't have a practice of having your client copied on emails. Deal with conflicts is number 7. Attorney must maintain independent judgment at all times. Representing more than one party at the closing table should be practiced sparingly and only when it is clear that neither party will suffer any disadvantage from it. Comment to Rule 1.7 states, loyalty and independent judgment are essential aspects of a lawyer's relationship with the client. The professional judgment of a lawyer should be exercised within the bounds of the law solely for the benefit of the client and free of compromising influences and loyalties. So you want to make sure that your judgment is going to remain independent. If you are going to represent more than one party and you're permitted under the rules, you will need written informed consent from your client and make sure they're aware of what's happening. Otherwise, that's a definite ethical pitfall. Certainly, there are some per se conflicts that can't be waived with written consent, and though that's where attorneys also like a broker or the attorney has a beneficial interest in a title company. Those types of per se conflicts of interest can't be overlooked or can't be waived with even written consent of your clients. Deadlines, these are critical. Mortgage contingency, inspection contingency, time of the essence deadlines, rate lock expiration date should be calendared so not to be missed. Rule 1.3 is the applicable rule. A lawyer shall not neglect a legal matter entrusted to the lawyer. So what I would suggest is having 2 methods of calendaring your important dates, whether it's on your phone, also maybe a desk calendar or some other calendar that you can put in both those dates. So you have multiple locations and one can't be overlooked. Take account of your trust account. It's so important that you safeguard the funds of your clients. And that's done by maintaining your escrow account. There are particular requirements for each account. I'm just going quickly through this because I know we're running short on time, but you can set up an interest-bearing account, but there are certain, every attorney should have an IOLA account, interest on lawyers account, and qualified funds should be deposited in an IOLA account, meaning they're small amount or held for a short period of time. What's also important is that only an attorney admitted in New York can be a signatory on an escrow account. Paralegals, bookkeepers, office managers cannot be signatories on an account. And a signatory is responsible for the acts of co-signatories if a reasonable review of the records would have disclosed any conversion. So you want to make sure if you're a signatory on an escrow account and somebody else is also, don't put those duties on one specific person and rely on that one specific person. You have the duty to review those accounts as well. And Matter of Galasso touched on that, which said that attorneys must maintain appropriate vigilance over their escrow accounts, reconcile the accounts for account errors, review the bank statements, not only in paper version, but verify them online through your banking online system. There are two ways to protect if there's any fraudulent checks that are used from your account. There's a positive pay system, which is essentially the company provides an upper list to their bank with any check that they've issued. If these don't match, the bank will clear the check. And a reverse positive pay system, which essentially the company reviews a bank list and authorize any specific checks on that list. Lastly, just simply be careful out there. Become familiar with the rules. Read the ethics opinions as they come up. There's over 1,000 ethics opinions that are posted on the New York State Bar Association website. I periodically monitor that for any new ones. Just check as they come up. They may be pertinent to real estate transaction or they may not. But in any event, there are various opinions that you will find valuable. Ask questions, reach out to the New York State Bar Associations or Ethics Committee of your local bar association for guidance. Follow your gut. If it doesn't feel right, there's probably an issue. Watch for red flags. We went through a number of red flags in this presentation alone. Just make sure. And lastly, know yourself. Make sure you're not overloading yourself. Make sure you're able to, properly represent somebody for this matter. You want to make sure that you give sufficient time for each matter, the time that it needs, so you're not falling into these ethical pitfalls. And when you need a break, that's important. Everyone needs a mental break, especially now. It's a crazy time, and we as attorneys, we live in a stressful world, in the office and out. So it's so important to just kind of, when you need to take a break, that's the most important advice I can give, really, is take a break when you need one. And with that, that concludes my presentation. Thank you all so much for joining us today, and look forward to seeing you at future ones.
Okay, so everyone who wants to stay, we're just going to stay for a few Q&A. So is there a form or a sample letter used for a retainer?
There is a sample form. I like to I've created my own form just over the years. There is one that there's one that you can get from the New York State Bar Association. There is also one that's a sample engagement letter that was provided when the New York Code of Rules and Regulations was issued, when that specific statute was issued requiring the engagement letters. So I know you can find it there as well. If you would like, you can email me directly. I'd be happy to provide you with a sample engagement letter or different ones. We may actually have one that's on our website, I'm not sure, but if not, I can, if you want to email me directly, rgiorno@judicialtitle.com, I'd be happy to send one to you. And if you feel that, ask me any questions. If it's unrelated to retainer letters or engagement letters, if you have any other issues, feel free to email me and I'd be happy to answer that for you.
If a buyer declines a survey, would you recommend the buyer signing a waiver?
I'm sorry, can you say that again?
If a buyer declines a survey, do you recommend you get them to sign a waiver?
I would have them, in one form or another, acknowledge that, whether it's through a countersigned letter or at the very least an email that you can acknowledge their receipt of, saying that despite my advices and what I've stressed as an important aspect of a survey and what they provide, you've decided to go forward with the transaction without it. I would I would have something in writing, whether it's in a form of a waiver, a letter, or at the very least, an email, which you can confirm was received by the client. Something should, I think, be in writing, so that you can fall back on that if there's any issue going forward.
Are attorneys required to use encrypted emails?
They're not required to use encrypted emails, but you are required to take certain precautions, some of the ones I've already mentioned, updating your systems, making sure your software is up to date, and just maintain proper vigilance over your email. Any encrypted emails that come over are more of a policy issue that that particular law firm has instituted, or it could be a banking institution. You'll see a lot. Those are, they're not promulgated by the rules. They're not requiring you to do that, but just maintain the proper vigilance over those email accounts and provide whatever safeguards you reasonably can provide.
Okay. Is the attorney liable for the purchase of a property with no CO or violations, even with informed consent of the buyer client?
So what I'm understanding that question is saying, if you've advised your client to
Correct.
proceed, although there's no CO, the attorney's not going to be liable in that situation. Or at least I don't know how he would be. If you are informing your client of the importance of having a CO. Now, you need to also make sure you're wary of who you're dealing with. Is this a young couple that this is their first purchase, or is this a developer that you're dealing with that's saying, well, I'm just going to do renovations in the house anyway, so I don't need a CO, So you have to take a look at it in that way as well. But if you provide your client with the necessary informed information, make sure they're making an informed answer, an informed consent to going through with that transaction, you should have enough protections in that instance. But again, you need to do that in writing. Put it in writing.
I'm just going to ask maybe 2 or 3 more quick questions, and then we will end. Is it professional misconduct not to pay a small claims judgment?
Is it professional misconduct to not pay a small claims judgment? I mean, if you're looking at what professional conduct is, in that professional misconduct, it is the definition of it in the New York Code Rules and Regulation. They specify something that comes up, not an act that an attorney can do not only in a personal but also in their professional conduct. So, again, I'm not the arbiter in all of this, but I would say, the judgment itself, because you may be appealing the judgment, but if it's something that that may be due and owing to somebody, and despite your obligation to pay it, you're not going to pay it. I would. It's a kind of a gray area. I would resolve that type of an issue. Again, unless you have a defense to it, I would resolve it the best way you can.
Is it okay to blind copy clients on emails for transparency purposes?
Blind copy, I'm assuming you're meaning to another attorney. If that's the case, I would stay away from that because again, the rules talk about, that you need to disclose, you need to make sure your truthfulness of your statements, all of that information. I would not blind copy personally my client on any emails because not only does it fall into that area of how you're representing things to the other side, the attorney on the other side may come back with something you don't want your client aware of or you don't want to discuss with your client. So I would not recommend doing it. So I would avoid doing that in that instance.
Okay. Can an attorney charge a minimum retainer fee if the matter is cut short by a client?
You can charge a minimum fee. However, if those fees are not earned, whatever the balance is has to be provided back to the client. That has to be refunded back to the client.
Okay.
You can't get, essentially, the bottom line is you can't get paid for something you didn't do.
Okay. With the increase in price of houses in the current market, how does an attorney protect himself since many of the down payments are over the $250,000 FDIC limit?
Well, I mean, what you could do is, first of all, you want to make sure that the account is being, the account that's being used is actually FDIC insured. Now, whether you're going to have a bank failure, it depends. Some banks are just too big to fail anyway. So you have those types of protections. And that's why in your contract, it'll indicate what bank those funds are going to be deposited in. So I would say, number one, to protect yourself, make sure that deposit is, going into an attorney escrow account at a reputable financial institution that has FDIC protections. If you are concerned about limits, you could also work out where if the attorney is willing to do this, separating accounts, possibly, putting them in different institutions, but that's something that you'd have to work out with the attorney on the other side. But again, if they're FDIC insured and it's a reputable institution, I would say that you've done your due diligence with that.
Okay, so that will be all for today. Thank you for taking all those questions. We appreciate it. And as a reminder, I'm going to send this afternoon all of the material and the affirmation to everyone who was on. So look out for that. And I see some coming in already, so you don't have to send it a second time. I'm just going to resend all the material to everyone in a little while. And as a reminder, we are skipping June. I know June gets crazy for everyone, but we are going to start again strong in July with our CLEs. We try to do one every month. So if you don't see anything for June, you did not miss it, and we'll begin again in July. And thank you again, Russ.
Thank you.
Have a good day, everyone.